Okay, good afternoon. This is Judge Lopez. Today is Friday, April the 10th. I'm going to call the first day hearing and ascend that elements 2690440. Today's hearing is virtual. I'm going to ask that you please hit 5-star. I'll also ask that you please make an electronic appearance. Just go to the Southern District of Texas web page. You'll find my home page and a place to make electronic appearances, and you'll find a link to this case. But let's get started. I'm just going to unmute the lines in the order in which I see them. The 202 number. A 202 number. All right, give it another shot. The 214 number. Mr. Manns, check your line. You may have muted yourself. Now, let's give another number then. Let's go with a 516.
Yes, good afternoon, Your Honor. Sunny Singh, Walgacho, on behalf of certain CLN investors.
Okay, good afternoon. A 214 number?
Good afternoon, Your Honor. Ryan Manns, Norton Fulbright, proposed counsel for the debtors. Your Honor, I'm also joined today by the Ascend Elements CEO, Mr. Lynn Austin, who's on video. And I'm also joined by Adam Titus, our Chief Restructuring Officer, and the Alvarez and Marcel Jeffries NRF teams.
Okay, good afternoon. A 202 number.
Sorry about that, Judge Lopez. I had someone ringing in and I hit end call instead of switch. So Jason Rupp for the U.S. Trustees.
Good afternoon. All right, anyone else, please hit 5-star and I will unmute your line. I know there are a number of parties who have filed pro hocs. You're more than welcome to appear today. We'll get to them. Is it 917 number?
Good afternoon, Judge Lopez. It's Rob Lemons with Goodwin Proctor on behalf of Fifth Wall.
Okay, good afternoon. And a 713 number?
Hi, yes, this is Madison Howeisen on behalf of Turner Cookosing Joint Venture, and I'm here also, I believe, Mr. Lawrence Wilkes with Winston and Strawn is also on the line.
Okay, good afternoon.
Good afternoon.
For the lines that I have unmuted, I'm going to keep you unmuted on my end. I'd ask that you please monitor yourselves, keep your line on mute, and just so we can all hear each other until it's time to address the court. Not, I'll turn it over to Debtors Counsel.
Thank you, Your Honor. Ryan Manns again on behalf of the debtors. First of all, thank you to Chambers and your staff for all of your assistance with coordinating the logistics for today's hearing. Thank you as well to the United States trustee for the constructive feedback on our first day motions. And a special thanks to the company and all the advisors for all the hard work to prepare for the filing and the support for today's hearing. Your Honor, we prepared a brief PowerPoint presentation that we would like to share with the court that addresses some background information on the company, why we're here, and our objectives for the case. If you could please share the screen with Ms. Moshika, we can walk through our overview.
Okay.
Great. If we could just move to the next slide, please. So, Your Honor, I'll start with our first slide, which is our senior management team, again, led by our CEO, Mr. Lynn Austin. And Mr. Austin is our first day declarant. Other members of our management team include Mr. Deacon Powell, who's our general counsel, Eric Gretz, who's our chief technology officer, Barbara Knight, our chief administrative officer, and then Mr. Ahmed Alouish, who is our CFO. Your Honor, this team has inherited some really significant challenges from their predecessors, but have nevertheless worked incredibly hard to transform the company over the last year. And then beyond the senior management team, Your Honor, we have a very talented operations team and over 100 employees. So Your Honor, what is Ascend Elements? Ascend is in the business of recovering critical minerals from used lithium-ion batteries and gigafactory scraps to create black mass. Because of its emphasis on domestic production and critical minerals, as you would expect, Ascend's operations are extremely important to national security. Ascend refines black mass at scale into battery-grade materials, including lithium carbonate and PCAM, and they do this by utilizing its proprietary hydro-to-cathode technology. The company operates a black mass shredding and lithium carbonate facility in Covington, Georgia, which specializes in the pretreatment and shredding of black mass. The company also holds a 50% interest in an operational battery metals recovery joint venture in Poland. In addition, the company's assets include a battery material plant in Hopkinsville, Kentucky, that is currently under construction. The Hopkinsville plant is designed for the production of lithium carbonate and PCAM at commercial scale. So, Your Honor, Ascend leads the development of North America and Europe's domestic supply of critical minerals and battery minerals through urban mining and proprietary application. It produces new supplies of lithium carbonate entirely from recycled metals. Domestically, it produces high-performance engineered battery materials critical to EVs and battery energy storage systems. The company has access to a 336 million EU grant and 293 million EBRD loan to develop facilities in Poland. The company is the first and only U.S. producer of lithium carbonate from 100% recycled content. In addition to its other assets, the company also has 154 patents granted or pending worldwide. As we move to the corporate org chart, I just want to highlight the overwhelming majority of operations run through the parent company, Ascend Elements, Inc. Ascend Elements Poland hold the company's interest in the Polish JV, and the other Polish entity was formed to hold the equity in the Poland companies. Ascend Elements UK and France are relevant to the company's import-export logistics, specifically with feedstock, purchasing and sales within the UK and the EU. And then Ascend Elements US was formed to support the multiple executive team members that live and work in Texas. On our next slide, we have our capital structure. We have approximately $20 million in senior secured convertible notes, another $83 million in junior secured convertible notes. We have a mortgage in Kentucky with approximately $400,000 outstanding, and then approximately $120 million in statutory lien claims.
Mr. Manz, I think I'm having some issues on my end on presenting this, sharing the screen, and I don't want it to affect what y'all are doing over there. So let's just proceed. I apologize. If somebody can just file the deck, it would be helpful for me to see it. But I think I'm just having some, I don't know, maybe what's going on. But I apologize. But please continue.
Thank you, Your Honor. We're happy to file that on the docket as soon as possible. And the last part of our capital structure, Your Honor, that I want to highlight is that we have approximately $36 million in unsecured claims. So when we speak to the key events leading to the Chapter 11, they include significant cash requirements that came due before the company achieved commercial scale operations. There are also legacy liabilities that attributed to project mismanagement that was largely attributable to the former management team. There have also been numerous construction delays and disputes, and specifically at the Hopkinsville, Kentucky plant construction, which has been suspended, and it's approximately 60% complete due to disputes with TKJV and numerous subcontractors. There's also been market volatility in black mass, lithium, and PCAM that have further hindered profitability. Your Honor, our objectives for the case are pretty straightforward. We want to preserve and maximize value as a going concern. We need to stabilize operations. And then we want to focus on maintaining safe and compliant operations as well. Our goal is to facilitate an orderly sale and to continue to work with lien holders and other stakeholders throughout the process. As a preview of what's to come, Your Honor, we believe we have some straightforward first day motions for your consideration. Again, we've had an opportunity to speak with the United States trustee and have adopted their comments. My colleague, Mr. Jason Blanchard, will present our cash collateral motion. We have negotiated extensively with counsel to the senior secured note holders, and we have a consensual formal order that we intend to present to Your Honor today. And then on the first day motions, I'll have my colleagues present on those matters. Your Honor, I'm happy to answer any questions before we move to the next phase of the presentation, but I'll pause there for a minute.
No questions at this time. I appreciate it. If there's anyone who wishes to just briefly tell me something before we jump into the motions, now would be the time.
Thank you, Your Honor. Can you hear me okay?
Just fine, Mr. Singh.
Okay, thank you, Your Honor. Nice to see you. And Your Honor, Sunny Singh Walgachal on behalf of the senior CLN holders and certain junior CLN holders. I'm joined today by my partner, Stephanie Morrison. As I mentioned, we represent the largest of the CLN holders, both in the senior and junior class. Your Honor, I'm going to be very brief. I rise just to introduce who we are to the case, let you know who we're representing. Your Honor, our clients have supported this company in its efforts related to its balance sheet needs up to today, including through their significant investments in the convertible notes that are in the aggregate about $100 million that were entered into in last June and December. We continue to be supportive of the company. We're supportive of the relief requested today. We appreciate Mr. Manns and his team and the company and their advisors working with us. We, as Mr. Manns indicated, do have an agreed form of cash collateral use order that our clients have signed off on. And, Your Honor, we just look forward to working constructively with the company, its stakeholders, and other interested parties in the coming weeks. And just wanted to say that. Thank you.
Thank you. Anyone else?
Yes, thank you, Your Honor. Jason Orr for the U.S. Trustee. I just wanted to confirm what Mr. Manns had just represented moments ago, and thank Mr. Manns and the rest of the Norton Rose team for working with us on incorporating our comments. So you'll probably be hearing very little from me today, unless you have any questions. But from my perspective, I believe that we're all resolved on any open issues with the first day request.
Okay. Thank you. Okay. Mr. Manns, I'll turn it back over to you.
Thank you, Your Honor. Your Honor, as a housekeeping matter, the debtors seek to have Mr. Austin's first day declaration, which can be found at docket number 11, as well as the declaration of Mr. Titus, which can be found at docket number 19, both admitted into evidence.
Any objection to the admission of these declarations for purposes of today's hearing? Okay, they're admitted.
Thank you, Your Honor. With that, I would like to turn the virtual podium over to my colleague, Mr. John Conover.
Okay, Mr. Conover. All right, let me unmute your line here.
Good afternoon, Your Honor. Can you hear me?
Just fine. Good afternoon.
Excellent. Good afternoon, Your Honor. John Conover of Norton Rose Fulbright, proposed counsel to the debtors, pro hoc vice motion pending. I'll be addressing agenda items 4 and 5 based on the agenda that was filed on the docket. Your Honor, the first item is the creditor matrix motion that was filed at docket number 5. With this motion, the debtors seek authority to file a consolidated creditor matrix across both of the debtors, to file a consolidated list of the 30 largest unsecured creditors, to redact any personally identifiable information from that matrix and any documents that would be filed in the case, and finally, the debtors seek approval of the form for notifying creditors of the commencement of these cases. With respect to redaction specifically, this request is appropriate and necessary in light of the many privacy laws that the debtors are subject to. The primary information being redacted here is home addresses and email addresses of individuals. As mentioned before, we've conferred with the United States trustee and we have incorporated their comments. Unless Your Honor has any questions, the debtors request entry of this order.
Anyone wish to be heard in connection with the creditor matrix motion? Okay, the motion's granted.
Thank you, Your Honor. Turning to the next item on the agenda, docket number 6, which is the debtor's motion to extend time to file schedules, statements of financial affairs, and reports under Rule 2015.3. The debtors here seek an extension of 45 days for a total of 59 days after the petition date to file schedules and statements. That would make the deadline here June 8, 2026. The debtors seek this extension out of an abundance of caution, but given the potential sale and expedited timeline, the debtors aim to file the schedules and statements as soon as possible. The debtors have voluminous books and records, as well as a complex array of contract counterparties and types of creditors. And so while the debtors and their professionals are working diligently to prepare the schedules and statements, the additional time requested will help to ensure accuracy and completeness. As before, we have consulted with and incorporated comments from the United States trustee into the proposed order at docket number 6-1. We're also aware that the extension will put the U.S. trustee outside of the normal period in which they hold 341 meetings, and we understand that the U.S. trustee has the ability to call the initial meeting within that time frame and continue it for a more fulsome meeting with the benefit of complete schedules. And so, unless Your Honor has any questions on this motion or the proposed order, the debtors respectfully request entry of the order at docket number 6-1.
Okay. Anyone wish to be heard? Okay. The motion is granted.
Excellent. Thank you, Your Honor. With that, I will turn the podium over to my colleague, Ms. Makerska.
Okay. Ms. Makerska. Let me, if I've unmuted you. There you go.
Good afternoon, Your Honor. Maria Mokrzycka of Norton Rose Fulbright, proposed counsel to the debtors. Can you hear me okay?
Just fine.
Your Honor, I will be addressing agenda item number 6, the wages motion, which was filed at docket number 14. The debtors seek authority to pay pre-petition wages, salaries, employees, benefits, and related obligations. The debtors employ approximately 102 employees and have also retained 14 independent contractors and subcontractors. Those employees and contractors provide essential services and are critical to debtors' businesses. As of the petition date, the debtors estimate approximately $1,401,700 in outstanding pre-petition compensation and benefits. These amounts include employee compensation, payroll taxes, benefits, and other related obligations. The motion does not seek to pay any employee above the priority cap of $17,150. Your Honor, this motion is very important to the company and its management because it sends the right message that the debtors are taking care of their employees at the outset of the Chapter 11 cases. It reassures employees and contractors that they will continue to receive their wages and benefits and that the company values their employees. For those reasons, the requested relief is necessary and appropriate. Unless the court has any questions, the debtor respectfully requests entry of the proposed order.
Does anyone wish to be heard with respect to the employee wage motion? Okay, I've had an opportunity to review the proposed order. It looks good to me. I'll approve the motion.
Thank you, Your Honor. Next, I will be addressing the agenda item number 7, the debtors' utilities motion. As the first day declaration explained, these Chapter 11 cases were filed to preserve liquidity, stabilize operations, and pursue a value-maximizing transaction. The utilities motion serves those same goals by minimizing the disruption and preserving the value for the estate. The debtors depend on electricity, gas, water, telecommunication, waste removal, and similar services to operate safely and without any disruption. The debtors pay around $294,000 per month in utility expenses, and certain providers had already held around $499,000 in letters of credit or surety bonds. The debtors propose to an additional $20,316 deposit into a segregated adequate assurance account between 10 business days, which reflects roughly one-half of average monthly utility costs after accounting for those existing deposits. The debtors will also pay post-petition utility obligations in the ordinary course of business. The proposed order also protects utility providers in the event of post-petition default. Your Honor, we shared the proposed order with the United States trustee and we incorporated their comments. Unless Your Honor has any questions, the debtor will respectfully request that the court enter the order at docket number 15-1.
Okay. Does anyone wish to be heard with respect to the utilities motion? It seems... Yeah. Yep, they're receiving adequate assurance, and they can always come back and ask for more. Okay, I'll get this signed and on the docket. Motion's approved.
Thank you, Anand. This completes my presentation, and I will pass the podium to Mr. Bercium.
Okay.
Good afternoon, Your Honor. Can you hear me just fine?
Just fine. Good afternoon.
Wonderful. Thank you. For the record, I'm Michael Berthium on behalf of Norton Rose Fulbright, proposed counsel to the debtors. I have 4 motions to bring to the court today. I'm happy to go in any order, Your Honor, but for convenience, I had plans to go in order of the agenda. So up next, if that's okay, would be docket number 10, the motion to continue insurance programs.
Okay.
Okay, great. This motion seeks entry of an order. They'll give us 4 purposes, really. The first is to continue to pay our pre-petition insurance programs and any obligations that have accrued pre-petition. It also allows us to renew those insurance programs as that comes up post-petition. And also it allows us to continue to honor our pre-petition premium financing agreements, which I'll explain briefly. And then like the insurance programs, it authorizes us to enter into new premium insurance programs and financing arrangements as necessary. So from a very high-level view of the insurance programs, Your Honor, and you can find this in the declaration at paragraphs 87 through 90. The debtors maintain 43 insurance policies. These are all essential to operations. They cover things like the debtor's commercial liability, any equipment breakdowns, environmental liabilities, and things of that sort. And annually, these premiums on all these policies run about $6.6 million. Of course, that's too much to pay in a lump sum, so generally these debtors finance the annual premiums through the premium financing agreements that I discussed. And under these agreements, the debtors pay generally about 25% of the premiums up front, and then the remainder in monthly installments. So with all this together, about $1.165 million comes due under these financing arrangements within the first 30 days of the case. That might be a little high, relative to the case. The explanation for that is recently the debtors had to rework their insurance programs to account for like certain production lines that weren't operational. So instead of paying full freight to include production of those lines, the debtors determined that it'd be better to self-insure certain of those assets. So this shift actually saved the debtors about $800,000 annually. But in the near term, it did require the debtors make a new down payment on the premium financing arrangements. Mm-hmm. So $668,000 of what's coming due in the first 30 days of the case is actually a down payment on a new premium financing arrangement. And then the rest of the 1.165 is, of course, the general monthly installments. So in addition to these, the debtors also maintain surety bond programs and letters of credit, which Ms. Mortuska spoke about in the utilities motion. These generally provide, of course, financial assurances to those parties, and those businesses are required to continue to do business with the debtors. So we ask this relief, Your Honor. First, under Section 1112 of the Code, it, of course, requires that we maintain adequate assurance, and maintains that we keep these insurance policies in place as adequate assurance. Then if we don't, it's cause for dismissal of the case. And Your Honor, we also think under 363C of the Bankruptcy Code that we would be allowed to do this as an exercise of the ordinary course of business. And then third, Your Honor, even if it wasn't an ordinary course, 363B allows us to use property of the estate based on our business judgment. And of course, the debtor submits this would be an exercise of his business judgment. And if you look to paragraph 87 of the declaration, you see testimony that the insurance policies are essential to the ongoing operation of the debtor's business, and entry of the order would be necessary to ensure uninterrupted coverage under the insurance policies. So on that record, Your Honor, we would, of course, request that the court grant the motion and enter the proposed order.
Does anyone wish to be heard in connection with the insurance motion? Okay. This is obviously one of the more important motions, especially with the nature of the debtor's business, and maintaining insurance is really important throughout this entire case. It preserves value for the estate. The relief requested is reasonable. It's required. And today's the day to get it started. So I'll grant the motion.
Thank you, Your Honor. Moving on, the next item on the agenda is at docket number 17. It's the debtor's motion to pay taxes. This motion requests authority for the debtors to pay taxes and fees incurred by the debtors. Like all of us, the debtors in the ordinary course of their business are subject to a variety of taxes. These are described in more in depth at the first day declaration of paragraph 85. Generally, though, these are income and franchise taxes, property taxes, regulatory fees, audits, and then expenses that the debtors incur from their tax service providers. I think it's important to flag that during this first day relief, the debtors aren't seeking authority to pay pre-petition amounts under property taxes that are outstanding, and we're not seeking authority to pay for our tax service providers at this time. This narrows the debtor's request at this time just to income and franchise taxes, regulatory fees, and audit fees that may be accrued pre-petition, and that's a pretty small amount. And then, of course, the authority to pay taxes and fees as they become due in the ordinary course. The authority for requesting these, Your Honor, is threefold. First, certain of the taxes and fees may not be property of the estate. We certainly just hold those in trust for certain of the taxing and regulatory authorities. Second, certain of the taxes and fees may be entitled to priority treatment. And then third, payment of the taxes and fees may be allowable as an exercise of the debtor's business judgment. And in paragraph 84 of the declaration, Your Honor, you see testimony that we believe payment of the taxes and fees will preserve estate value, and then failure of the taxes and fees could have an adverse effect on the debtor's ability to operate. And then further, some of the amounts may be collected directly from the debtors, directors, officers, and employees. So for all these reasons, we think it's in the business judgment of the debtors to pay these taxes. So on that record, we ask that the court enter the proposed order, and of course, in accordance with paragraph 4 of the complex case procedures, we ask that it be entered on a final basis.
Anyone wish to be heard? Okay, motion is granted. You can pay your taxes.
Thank you, Your Honor. Next on the agenda is at docket number 9. It's the debtor's motion to restrict certain stock transfers. This motion requests entry of an order which would implement restrictions on transfers of the debtor's stock, would approve notification procedures for doing so, and then direct that any purchase or sale in violation of that order is void. The reasoning behind this motion is a little dense. I haven't learned a lot about the tax code, but I will do my best to summarize the relief we request and the reasoning for it. If you look to paragraph 91 in the debtor's declaration, you'll see that the debtors have generated over $300 million in net operating losses and other similar tax credits, and we've defined these broadly as tax attributes. These tax attributes, I understand from our tax partners, are very valuable to the debtors. They can be used to offset future taxable income. But I also understand that these tax attributes can be lost. Relevantly, if the debtors undergo what's called an ownership change, and especially if that ownership change is not carried out by a Chapter 11 plan, the value of those tax attributes can be materially harmed. So therefore, the relief requested in this motion seeks to prevent any inadvertent ownership change that would harm those tax attributes, which are property of the estate and is subject to the automatic stay. But in fairness, the debtors don't seek to ban all trading of stock, full stop. Instead, the motion proposes certain procedures to strike a balance. We do want to allow trading within reason, but we want to enable the debtors and our advisors to monitor, stop, and if necessary, avoid a sale that could have a detrimental effect on the estate. So as I alluded, Your Honor, the basis for this relief is essentially a motion to enforce the automatic stay and enjoin any actions that would adversely affect property of the estate. Courts have ruled that these tax attributes are property of the estate under Section 541, and that as property of the estate, their transfer is subject to the automatic stay under Section 362. And again, we're not seeking to enjoy these transfers wholesale, just implement procedures and oversee and approve transfers as they may come up. And again, Your Honor, if you look to paragraph 92 of the declaration, we see that these tax attributes are valuable to the estate and could provide a significant benefit to the debtors down the road. So on that record, we would request that the court issue the order.
Do you need a final hearing date?
Yes, Your Honor. On this one, under the complex procedures, we would need a final hearing date. So we request the court hear this, within 25 days or so.
What date do you have in mind?
I don't believe we've discussed internally, and of course we'd have to get with our opposing counsel as well.
Let's have some fun. Let's pick one ourselves. What do you want?
Okay.
I get to
pull up our calendar, Your Honor.
Mr. Mans, what are you thinking?
Your Honor, we were hoping, and I don't think we've actually reached out to Chambers yet to confirm the court's availability, but a little bit less than 30 days from today for our second day hearings. We also have, and I don't mean to jump the gun, but at the conclusion of our hearing today, we'd like to talk a little bit about the big procedures motion that we'll be filing shortly. So we anticipate setting that for hearing.
I'll be ready to talk about that.
But yeah, if we could.
But let's pick a date because I'm going to be disappearing. I want to make sure that I'm not going to. Let's go. So 30 days. That puts us. Let's see.
If it could be just within 30 days, Your Honor, as well, because we have a milestone in our cash collateral order that requires entry of the final within 30 days.
Yeah.
To the court's availability.
Yeah. Let's see. What about May? Rosario, can I do May 7th at 1? Oh, Rosario said 2. So May 7th at 2. Why don't we do that?
Thank you, Your Honor.
And then we'll set an objection deadline of, and then we'll keep it simple. Yeah, we'll do Friday, May 1st. Give me 1 second.
Thank you, Your Honor.
2 p.m. May 1 as the objection deadline. Mr. Bethune, how does the motion define a substantial equity holder? Who's going to get the substantial equity holder notice?
Yes, Your Honor. Anyone, if I recall correctly, anyone that holds more than 5% or 4.5% of stock is defined as a substantial equity holder, and they'll receive notice.
And what is this notice procedure?
This notice procedure alerts them to these procedures that we have in place, and they'll have to reach out to us if they decide that they want to sell any of their stock above 4.5%. So they'll have to reach out to the debtors with the proposed transaction, and we have 30 days to file a motion on the docket approving the sale. If we don't file anything, Your Honor, it's a negative notice. If we don't file anything, then the sale is quashed.
And this is to preserve NOLs?
Yes, Your Honor.
What are NOLs?
This prevents, I'm sorry?
What are NOLs?
NOLs are net operating losses. Anything when you lose money during a calendar year for taxable purposes, you can carry forward those losses and assert them against taxable gains and successive years.
All right. This one. See, you knew more than you thought you did about the motion. You sounded all like you were worried about it. You didn't really understand it, but you actually do. So, no, it makes sense.
Quite the undertaking.
Okay. Now, I'll grant the motion. It's an interim relief. We'll consider everything on a final, but we'll pick the date. We'll go with that. What did I say? May 7th at 2, and then objection deadline May 1. Okay. The motion's granted. Where do we go next?
Thank you, Your Honor. You have one more motion for me before I see the podium. That will come from docket number 16, which is the debtor's motion for authority to pay certain critical vendor claims.
All right.
In this motion, Your Honor, the debtor seeking an order that would authorize but not require us to pay pre-petition amounts to vendors that the debtors deem critical to their ability to maintain essential operations. This is described in the first aid declaration, paragraphs 81 through 83. The debtors, along with we and then our advisors at A&M, put a lot of effort into distinguishing these vendors that we believe are truly necessary to operate the debtor's business. And I will flag at this stage, Your Honor, the relief is very narrow. It really is only those vendors that keep the facility safe and keep the facilities operating in compliance with the environmental and regulatory regimes that they operate under, and those vendors that we're going to deem necessary to preserve the value of the debtor's assets, such as safeguarding inventory, storing inventory, maintaining the equipment that we're looking to post for sale. And Your Honor, I submit that this relief is appropriate as an exercise of the debtor's business judgment. Now, if you look to paragraphs 82 and 83 of the declaration, and as is outlined in COSERV as well, you'll see that the debtor has determined that these vendors are critical to the debtor's business, that without these vendors, the debtor would be harmed and would struggle to preserve asset value, and that there is no practical alternative to the vendors. So based on this record, Your Honor, we request that the court enter the proposed order. As you see, there is an interim order and a final order. The interim relief and the final relief numbers are the same, just because it's such a small amount. We would, of course it out over the course of the month, but it's such a small amount, we didn't see a reason to split it up into interim amounts and final amounts.
What's the amount that you're seeking? What's the amount you're estimating?
$1.35 million.
Does anyone wish to be heard in connection with this motion? Just looking at the order. Okay, I'll grant the relief requested, and we'll set the final hearing date at the same date, with the same objection deadline as the prior relief, so we can have it. Okay, motion is granted.
Sounds great. Thank you, Your Honor, and I'll pass the podium over to Mr. Blanchard.
Okay.
Good afternoon, Your Honor.
Good afternoon.
Can you hear me okay?
Just fine. Good afternoon.
Thank you. For the record, Jason Blanchard of Norton Rose Fulbright, proposed counsel to the debtors. I'll be presenting the last two motions of today's hearing. First, the cash management motion at agenda item number 12, which appears at docket number 7. And second, the cash collateral motion at agenda item number 13, which appears at docket number 18. With respect to the cash management motion, the debtors seek authority to continue operating their existing cash management system, maintain existing bank accounts, pay certain related pre-petition obligations, and continue to perform intercompany transactions all in the ordinary course of business. The debtors operate a centralized cash management system overseen by their Treasury Department with internal controls governing all flows of funds. As of the petition date, the cash management system consists of 20 total bank accounts, 7 of which are owned and controlled by the debtors that are held at Bank of America and Silicon Valley Bank. The remaining accounts belong to non-debtor affiliates. A schematic and a full bank account list were attached as exhibits to the cash management motion at docket number 7-1, 7-2, respectively. Now, in terms of cash flow, the operating revenues and loan draws fund the main operating account, with the Bank of America depository account serving as the reserve and tops it off as needed. And from that main operating account, funds flow out to cover payroll, vendor payments, debt service, professional fees, and other disbursements that all is reflected in the schematic. Your Honor, the debtors also maintain a corporate credit card program with American Express, and we're seeking authority to honor the outstanding pre-petition balance and continue the program post-petition. If discontinued, American Express could seek collection directly from individual employees who use the cards in the ordinary course, and that's a disruption to the debtors' workforce we want to prevent, especially as the debtors pursue sale on an expedited timeline. The debtors also seek authority to pay pre-petition bank fees that have accrued or remain unpaid at the petition date to maintain their ongoing banking relationships that are essential to the operation of the cash management system. Next, Your Honor, the debtors also seek authority to continue intercompany transactions in the ordinary course, including monthly payments to non-debtor foreign affiliates. Principally, the debtors' Polish joint venture, which operates a battery disassembly and black mass production facility in Poland, whose continued operation is critical to the debtors' long-term production strategy and overall value. With respect to post-petition intercompany transactions with such non-debtor affiliates, the debtors proposed a cap of $100,000 on an aggregate basis, which we've referred to as the non-debtor affiliate funding cap in the motion, without further court approval, but with payments being consistent with the cash collateral order and budget. And any amounts beyond that cap would require separate court authorization. And again, the continuity of these payments are critical to preventing disruption to the debtor's business and preserving value as the debtors seek to implement a value maximizing process and achieve a transaction during these cases. Finally, Your Honor, to the extent the cash management system does not directly comply with Section 345 of the Bankruptcy Code or the U.S. Trustee Guidelines, the debtors have requested a temporary suspension of those requirements for an interim period of 45 days from the petition date to allow the debtors to work with the U.S. Trustee's Office on any necessary steps towards compliance. The debtors' banks are well-established, highly regulated financial institutions, and we do not expect this to be a material issue. Disrupting the cash management system at the outset of these cases would impose immediate administrative burdens, risk missed payments to employees and vendors, and it would undermine the operational continuity we are asking the court to help us preserve. We have conferred with the U.S. Trustee's Office in advance of this hearing and have incorporated its comments into the form of orders attached to the motion. And at this time, we're not aware of any objections to the cash management motion. For the reasons set forth in the motion and the first aid declaration, specifically paragraphs 69 through 78 of the declaration, we respectfully request that the court enter the proposed interim order attached to the cash management motion at this time.
Does anyone wish to be heard with respect to the cash management motion? Okay. I'm going to grant the relief requested on an interim basis. This is really just kind of allowing the debtor to ease into the Chapter 11 process, but still providing transparency as to where the money's held and how it moves and providing notice there. So I'll grant interim relief. Everyone's rights are reserved in connection with the final, and I'll set it for the same May 7, 2 p.m., May 1 objection deadline.
Thank you, Your Honor. Turning to the last item on the agenda, which is the cash collateral motion, the debtors seek entry of an agreed interim order authorizing emergency use of cash collateral on a consensual basis, granting adequate protection to what we defined as the pre-petition secured parties to the extent of any diminution in value of their interest in the cash collateral and other related relief. The evidentiary foundation for this motion is the declaration of Mr. Titus, which is can be found at docket number 19, which the court admitted in evidence earlier during the hearing. As mentioned, Mr. Titus is the chief restructuring officer of both debtors and is present in the virtual courtroom and available for cross-examination. The cash collateral motion is the most critical piece of first-day relief we're presenting here today. Without authority to use cash collateral, the debtors cannot operate. As of the petition date, the debtors do not have sufficient unencumbered cash to maintain their business operations and have not obtained post-petition financing. As Mr. Manns alluded to, the debtors entered these cases with the purpose of stabilizing operations, preserving the value of their assets, in order to execute on a value-maximizing sale process. With the assistance of the debtors' proposed investment banker, Jeffries, the debtors have commenced a marketing process for their assets and for debt financing. But that process requires time and access to cash. Without cash collateral, the debtors would be forced to immediately cease operations, terminate all staff, and abandon their assets, resulting in not only a potential hazard to the health and safety of the public, but a near complete destruction of the value of their estates. Mr. Manns also alluded to earlier today the debtors' capital structure. Just to cover that briefly, there are senior secured convertible loan notes that amount to approximately $20 million and junior secured convertible loan notes totaling approximately $83.1 million. The senior note holders hold first priority liens listed substantially all the debtor's personal property, including cash collateral, and the junior note holders hold second priority liens on the same collateral rather. And other than the note holders, we do not believe that any other creditors have an interest in cash collateral. Critically, here, Your Honor, the note holders have consented to the debtor's limited use of cash collateral, and the proposed order reflects a negotiated arrangement with those parties that have an interest in cash collateral and the reality that debtors have no available alternatives. As discussed in Mr. Titus's declaration, access to cash is necessary to stabilize and maintain operations, to potentially bridge to a DIP facility, and to provide the runway to explore a transaction. The use is necessary to fund payroll, payments to critical vendors, and service providers for safety and environmental compliance. The proposed budget that has been attached to the proposed order covers a 6-week period from the week ending April 10 through the week ending May 15th. In short, Your Honor, the budget is designed to keep the lights on, keep the workforce paid, keep the facility safe, and give the debtors the runway they need, nothing more. And in exchange for the use of cash collateral, the debtors are providing the pre-petition secured parties with a comprehensive adequate protection package designed to protect them against any diminution in value of their collateral during the pendencies of these cases. And just to touch on the adequate protection briefly, the senior note holders will receive first priority senior adequate protection liens on all collateral subject junior only to the carve-out, super priority administrative expense claims under Section 507B of the Bankruptcy Code, payment of their reasonable and documented professional fees of their advisors, and weekly reporting and information rights. The junior note holders will receive similar, but a little bit different, will receive second priority adequate protection liens and super priority administrative expense claims junior to the senior note holders. The senior note holders have also conditioned the debtor's use of cash collateral on Section 506C and 552B waivers and a marshaling waiver. Last, Your Honor, I wanted to flag for the court the sales-related milestones that are reflected in the order that are designed to move the cases expeditiously towards a value-maximizing outcome. The milestones include a bidding procedures motion to be filed within 2 days of the petition date, a bid deadline of May 9th, bidding procedures order to be entered by April 16th, and a sale order to be entered by May 17th. The debtors are optimistic these milestones are achievable and intend to file the bidding procedures motion in short order. We understand, I'll defer to after the hearing to scheduling issues, but we understand that Your Honor may have...
Yeah, go ahead.
Yeah, we understand that Your Honor may have availability for a hearing on next Tuesday, the 14th.
For what?
For the bid procedures hearing.
You're going to... Yeah, but if you file it on Sunday, that means you're going to give people 1-day business notice. Why would I...
Our intention is to file it this evening, Your Honor.
Let's talk a date about that. What do you... I'm looking at the budget, so I know why you want a hearing early. I haven't read it, so I don't know what's coming. I'm willing to give you I don't know what's in it. And I can tell that the budget, if it's kind of a down the fairway one, we can rather give as much time as necessary. We could do, I don't know, I think I can do the morning of the 16th, like 11 a.m.
That would be great. Thank you, Your Honor.
Subject to everyone's rights, obviously. Yeah, why don't we do that? And get it on file as soon as you can and give people as much notice as possible and in the most efficient way possible. And let's talk. It sounds like you've been marketing this, but let's just get a good, open, transparent process about bidding and pick dates and we'll see where it goes. But Anyone wish to be heard in connection with this cash collateral interim relief interim relief requested?
Good afternoon, Your Honor. Again, Jason Ruff for the U.S. trustee. There was just, Mr. Blanchard and I had some brief communications and then along with Mr. Wynn. There was one paragraph, I believe, that was going to be modified that would require for there to be a hearing before there was any foreclosure on any of the DIP collateral. Maybe I missed it, but I don't believe that revised order has been uploaded yet. And so perhaps if Mr. Blanchard could just maybe speak to that.
Yeah.
Yep, Mr. Ruff is correct. We agreed to that form of language, and we have not uploaded a revised form of order, but the revised form of order will include those changes.
You stole my thunder here, Mr. Ruff.
I try where I can, Your Honor. Thank you.
Okay. Now, someone's going to get me an order uploaded, but I will. Mr. Singh, do you wish to be heard?
No, Your Honor. I'm just here if you have any questions. We're fine with the order. I think there may be some other cleanup that's happening in the background to the order, but nothing substantive to my understanding.
Okay. Now, I understand what's going on, and it's clear that the debtor needs to use cash collateral, and the budget really is kind of a keep the lights on budget. I was looking at it carefully to just make sure that I understood it, but this one, it is just is what it is. It's just kind of a path to get to to kind of get to the process, and this is consensual. Makes sense. I'll grant the relief request. It's subject to the tweaks about getting a hearing, just in case there's a default. I think it's just important to keep that process. So get me a revised order, let my case manager know, and we'll get it signed and on the docket today. And if you can, fill in the interim and objection deadline as well.
Your Honor, just one quick comment, if I may.
Sure.
Just wanted to confirm for the record that counsel for Tennessee has reached out, and there are some cleanup comments that we're also going to make to the proposed interim order. And so I just wanted to confirm that for the record.
Okay. Y'all will get it to me. You've got if April 16th at 11 a.m. works, just go ahead and get it filed on the docket and let's set it there, and we'll see where it goes from there. All right.
Thank you, Your Honor.
Anything else we need to take care of today?
Your Honor.
Nothing further. Thank you again to Chambers and your staff for accommodating us on a Friday afternoon.
Have a good afternoon. Thank you.
Thank you.
Thank you. Thank you.